And again, for those who practice in this area, you'll know that the most frequent way in which written notice is given is when the Secretary of State writes to an individual and says that they're contemplating, or they're investigating rather, the way in which their nationality was obtained, because they believe that it was obtained by, for example, fraud or false representation, and then asking the applicant, or providing the applicant, an opportunity to respond and to say whatever it is that they would like to say in response to that before the deprivation order is made. And so it's really notable, and why we say that this is a watershed moment, is because the assessment of the tribunal, or the scope of an appeal before the tribunal, was significantly narrowed at this moment, where the Supreme Court says it's really for the Secretary of State to decide when the condition precedent has been met, and when her discretion should be exercised, and it's not the tribunal for the tribunal to substitute itself for the decision maker. And as we'll go on to see, the role of the tribunal in these circumstances is shrunk to reviewing the lawfulness of the Secretary of State's decision, not substituting the tribunal's own decision. And the court found that the upper tribunal had been right, that the first tier should have considered the deception in the citizenship application because it was relied on in the Home Office's written decision. Although the presenting officer didn't refer to it, they also didn't explicitly withdraw the point. And that considering that second question of Suleiman and whether that had been correctly decided or overtaken, the Court of Appeal said that the decision in the case of Suleiman wasn't decisive, that really they could depart from, the Home Office could depart from Suleiman in this case, because in Suleiman they'd focused on the legacy grant and hadn't suggested that this declaration of truth in the citizenship application would have led to a refusal.